Thank you everyone for joining us this afternoon, evening, and welcome to our second installment of the new labor law, where we are focusing on the implementing regulations. Some of you were with us a couple of weeks ago when we held the webinar on the new labor law and the features of the new labor law. As you can see, Charles will be presenting the webinar today. I encourage you to please submit your questions on the Q&A box throughout the webinar. We will be checking questions, and we will pause at certain times to answer some of these questions. And whatever is remaining, obviously, we will do as a discussion at the end of the webinar. Without further ado, I'm going to hand over to Charles.
Thanks, Samara. Thank you, everybody, for signing up. A pretty good crowd today, and that's, I think, indicates there's a high level of interest in these new labor regulations. I'm going to talk today. You know, last time I spoke about the statute, the new labor law, which was promulgated back in, I guess, October, and it took effect on February the 2nd. That's Federal Decree Law number 33 of 2021, and the law said that many of the specific details would be set out in implementing regulations. And the regulations have now appeared. They came out in early February. They took effect on the same day as the labor law, the 2nd of February. And so now we've got, they're not a complete statement of all the regulations and all the details on how the labor law is going to be applied, but it's certainly a first step, a first good set of regulations. And I'm going to talk to you about those today, primarily against the background of a labor law. And like Samara said, you know, you might have, I have questions. If you have any questions, raise them in the Q&A function, and we'll try to deal with them in the course of my comments. I'm perfectly happy to stop and address questions, because really I want to know what you, the audience out there in Zoom land, I want to address your concerns. So I've got a couple things I want to talk about, but I really want to address your concerns. So let me start on that basis. Feel free, please, to post questions, and we'll stop at opportune times throughout the presentation, which is going to be relatively short, right? Like 60 minutes at most, maybe 45 minutes of me talking, and then the rest will be hopefully answering questions from you. So let's go to slide number 2, Samara. I'm a partner in the law firm Afridi Angell. This is slide 3. Go back one. Here we are. Yeah, talk about the firm a little bit, just a little bit. We are the oldest established independent law firm in the UAE. We've been around since 1975, which means 47 years. So we're in middle age as a law firm would go. And we have a full service corporate practice, advising corporates on all aspects of doing business in the UAE and in this part of the world. We're part of a network called Lex Mundi, also another network called the World Services Group. Both are networks of independent law firms, very selective. Lex Mundi, some of you might have received emails from us or notifications from us. We're having a Lex Mundi regional conference next month here in Dubai with lawyers from all over the Arab League, the Middle East and Africa region. And so if that's of interest to you, send an email to Samara, and you'll get a chance to see kind of what we can do with friends in Lex Mundi on a regional basis. Now coming back to the topic at hand, let's go to slide number 3, Samara. I want to talk to you about these new regulations, these new measures that have now taken effect. The main statute is Federal Decree Law number 33 of 2021. The second statute referred to there is a much shorter one. It's Federal Decree Law number 47 of 2021. And that was designed to state some general principles on harmonizing the rules of employment in the UAE as between the public and private sectors. Okay, and then the implementing regulations under the labor law, Cabinet Resolution number 1 of 2022, which just came out this month. All three of these measures took effect on the 2nd of February. So they are all effective law now. They are all in effect. They all govern labor and employment relations today. Okay, let's go to slide 4. The first topic I want to talk about, I'm not going to talk about the regulations. Yeah, slide 4.
Sorry.
Yeah, I'm not going to talk about the regulations in the sequence in which they appear in the cabinet resolution, because that's not interesting to me. What I want to do is talk about topic by topic, and and simply to me, the topics that I find interesting. And if they're interesting to you as well, then that's great. And if they're not, then you can ask me questions about what you want to hear about. But, you know, we've had, going back to 1980, the labor law, the old labor law, allowed employers and employees to enter into employment contracts that contain restrictions on post-employment activities of a departing employee. Okay, so-called non-compete clauses or non-competition clauses. And they have always been subject to certain types of restrictions. There's always been a geographic scope restriction, undefined, but it's there as a quantitative matter. And it's designed to protect the employer from, again, the hiring away issue. You know, the bane of your existence if you're an employer in the UAE is that you recruit these employees, you train them, you get them to where they're finely honed instruments of your corporate purposes, and then, you know, some competitor hires them away. They go off with all the skills they've acquired at your expense. They might know proprietary information about your company. They might want to compete against you. They want to take your customer list. All these things happen. And so very often employers try to put non-compete clauses in the agreements, and the labor law, you know, within limits, allows these clauses to be enforced. But getting them enforced as a matter of practice is difficult. Now, the new labor law does, again, repeat this provision about non-compete clauses. It says that they are enforceable. For the first time, the labor law puts in a little bit more content. It says that if they are going to be there, they are to be enforceable only up to 2 years following termination of service. There are rules on when an employer can invoke a non-compete clause. And now, you know, there are some more provisions in the regulations that I think mean that the authorities are taking this seriously. They expect them to be, you know, followed by employers and employees, but they're also saying there are some situations when these non-compete clauses are not going to be enforceable. And now you're going to ask me what those what the regulations mean. It's kind of hard to say at the margins, but number one, it says that if the employer terminates the relationship and does so in a manner that's in breach of the statute, in breach of the labor law, or in breach of the contract, then the non-compete clause may not be enforced. Now, what does that mean? Termination without notice, termination without a legitimate reason, termination perhaps for some kind of wrongful motive, things like that, that are not non-legitimate. Termination that is not legitimate would be viewed as I think, under this rubric, and that would deprive the employer of the right to prevent the employee from working for the employer of his or her choice following termination of services. There's a phrase in the regs which puzzles me somewhat. It also says that you lose the right of the employer. You lose the right to enforce this clause if the termination is attributable to the employer. I'm not quite sure if there's something other than wrongful termination that this applies to. Surely it can't mean that if an employer terminates an employee's services with notice and goes by the book, they can't enforce the non-compete clause. That would be nonsensical. But anyway, I'm just reporting to you what the regs say at this point. And also, if the termination is done during the employee's probationary period, then the employer cannot enforce the non-compete provision after that. I think the rationale is then in this case is that the employee really hasn't learned much that can be used to harm the employer during the probation period. Again, remember that probation periods don't exist by force of statute, they exist by force of contract. So if your contract doesn't contain a probation period, then there isn't one. It's got to be in the contract for it to exist. There are going to be, there aren't yet, but there are going to be specific job categories that the Minister of Human Resources and Amortization will determine where a non-compete cannot be enforced. So bear that in mind. It does say that if a non-compete clause is challenged by the employee, the employer has to then bear the burden of proof that the employees, the former employees working for that new employer will cause harm. Because again, this is designed to prevent the employer from wrongfully suffering harm from employees being hired away. There's also a provision for the new employer to buy out, as it were, the non-compete clause by paying compensation 3 months' salary. Now that's got to be agreed by all three parties, old plus new employer plus employee, but that might also provide some scope to keep these kinds of disputes out of the courts. It appears to be, at least that's what the intent is. So that is, whatever happens, if you pay the previous employer 3 months' salary, you can go and work for your new employer. Again, it says the old employer's got to agree to that, but I imagine there's going to be some strong encouragement for all parties to agree and not let this dispute go to the courts. Anyway, that is, I think, an interesting topic. It's absolutely worth looking at going forward. I'd like to see if we actually are going to have these clauses enforced by the courts, by the Ministry of Human Resources. It looks like they're serious about it, but again, we haven't had any test cases yet. And I want to move to the next topic with that, if it's okay, Samra, to slide 5. Here's another topic that's interesting, and it's kind of, I'm not entirely sure how the labor law is going to treat this, but as a lot of you probably know, there are very, very detailed rules on how overtime calculation, overtime compensation is calculated. What triggers it, and then how you pay the employee that works overtime. But of greater interest, I think, there are exemptions. There are categories of employee job titles where the rules on overtime don't apply. That is, these are people who basically work well in excess of 8 hours a day, well in excess of 48 hours a week. They do it on a regular basis, on a normal basis, and yet do not claim overtime. Highly compensated executive level employees, that's the concept. The labor law and the regulations don't quite support that concept in full, but they do in part. Certainly, C-suite executives, chairmen, boards of members of directors, that level of person, those people can be exempt from the entitlement to claim overtime compensation. The second category is kind of interesting. It's persons that have senior managerial roles whereby they exercise the authority of the employer. The wording is a little bit unusual, but I think what this means is that they've got the authority to hire and fire. They've got authority over their department or over their section of the workforce, where they can make decisions that are properly speaking employer decisions. Hire and fire, dictate how work is done, this kind of thing. Now, offshore employees are a different category. They've always been kind of exempt because, people that work on offshore rigs, they work maybe 12-hour shifts over a rotation of 14 days or 30 days, and they're off for 2 months, and then they're back. They've never been subject to overtime exemption, overtime rules, and they still are not. Now, regulations under the old law contain this this kind of shift work exception, which is now continued in the regulations as well. What does that mean? I think it means when you're dealing with certain types of machinery that you really can't power down, something that's got to keep running 24 hours a day or else it just doesn't work. And you often have rotations of employees, shifts of employees working on those items in those kinds of workplaces where they're working in excess of 8 hours a day. And that again is okay. It's part of the job. Everyone knows it. As long as you don't work the average employee more than 56 hours per week, that's a new ceiling. Then these kinds of employees are exempt from overtime rules. And then a further category, which is new, tasks that are preparatory and supplementary to tasks at the workplace. Maybe you've got a shift of employees that have got to come in early and make sure the air conditioning is on and the server is working and everything is all right. And maybe there's a shift that leaves kind of late at the end of the day. In a factory, maybe there are people that come in early and make sure all the machinery is working, the power is connected, there are no hazards, stuff like this. Powering up, powering down, mobilizing and demobilizing. Those things, you can't have them going on when everybody else is at the workplace. It just gets in the way. So these things are done a little bit early, a little bit late. And those people are perhaps not subject to the rules on overtime. There will be further details coming out. And there will be some cabinet, either clarification from the cabinet or from the minister that will detail whether any specific additional categories are exempt from overtime or whether any of these categories are going to be more clearly defined. But it is not true, and don't go away thinking this, it's not true that every white collar employee, every management employee is exempt. It's a little bit narrower than that. And it's worth looking at the labor law and seeing whether the categories of employees to whom your workplace views as not subject to overtime, whether there's really a match there. Anyway, this is, I think, going to be an ongoing issue. There is a lot of flexibility in this and in other areas of the law for regulations to elaborate what the specific rules are, and I think we're going to see this develop further going on. And that is all I want to talk about overtime. I want to move on now to leave. If we can go to slide number.
Charles, can we pause? I thought maybe we can, yeah, we can pause for a couple of questions. Now, several questions have come in on probationary period, on vacation, on leave, but I thought maybe we could leave those till later. But one of the questions is on non-compete clauses. Controls for non-compete clauses. What is the extent of geographic scope? Article 12.1a.
Yep. Well, 12.1a, I'm not sure it says in 12.1a. It does require, the concept is there, geographic scope. And I was turning to it right here. Yeah, that's coming from the statute. Let me, again, backing up, what is the, maybe it's helpful, Sarah, to go back to slide 4.
Okay.
But what is the concept? You don't, as an employer, you don't have the right to limit an employee's right to pursue his or her livelihood following termination of services forever. There are limits on it, okay? Number one limit is it's only applicable to jobs where that kind of competition really can cause harm to the employer. It's not everything, it's only some types of jobs, and there will be elaboration on that. There is also a duration limit, okay? And that now, before it was left kind of vague, now it's 2 years. Geographic, that was also undefined previously, it remains undefined. I suggest to you that it's going to be really a geographic area within which there is active competition between this employer and the next employer, and you can show that harm will result if your employee starts working for the other employer within that 2-year time period. So I think I've seen some contracts where there's a worldwide non-compete. I don't think that's what the labor law has in mind. I've seen others that restrict it to the UAE, and I think that is what the labor law has in mind. Certainly a geographic scope that's this country, I think they would go along with that, okay? Now, if it's the GCC or the Arab League or any country within 1,000 miles of here or whatever, I think you would have to justify that and say there really is some kind of economic reason why, you know, companies in those other countries are taking away work from us, or we're competing for the same kind of work. And when they hire away your employees, they are obtaining some kind of wrongful advantage. That's what you've got to prove. So it's not going to be presumed. I think what the authorities are going to do is look at these kind of claims by employers skeptically. Bear in mind that if you wish to assert a non-compete clause and the employee who's left you is contesting it, you're going to have to prove that harm will result. So if the geographic scope is kind of too broad, or if the employee has moved far away, if the employee has moved from Dubai to Riyadh, for example, you're going to have to prove that the employee in Riyadh is going to somehow cause you harm by the nature of the work done for your competitor. That, I think, is going to be harder to prove than if the employee just, you know, went across town, across the street to somewhere else in Dubai. So geographic scope, still undefined, but bear in mind it's a question of harm, competitive harm, wrongful harm that the authorities are looking at. Does that help?
Yeah, I think that's good
any
enough.
other questions on that? Any other questions on non-competes?
No, that's the only one.
All right.
But there are a couple of other general questions. I thought maybe we can. This law is not applicable to DIFC companies, is it?
Well, yeah. The two financial free zones, DIFC and ADGM, have their own employment regulations, and those are followed there. The labor law does say, however, that it applies everywhere else. So in those two financial free zones, there is an express carving out of statutes that apply generally in other parts of the UAE. But the other free zones don't have that. So in places like Jebel Ali, for example, which has its own employment regulations, don't get me wrong, but those employment regulations supplement the labor law, they don't replace it. So these regulations and the new statute, it applies pretty much throughout the UAE, the only exceptions there being the DIFC and the ADGM.
Okay. There is a question on end of service benefits for workers. Would you like to take that one, or?
I will get to that after annual leave. 2 more slides to go, so I'll get to that.
Okay, let's.
Well, are there questions on overtime, on working days and all that, or not?
Actually, I think there was.
All right, I can address that now since it's on slide 5.
Are we on slide 5? Let me move to slide 5 first.
Okay. There it is, overtime. Mm-hmm.
I thought I saw something, but.
All right.
Yeah, is overtime pay calculated on basic or full salary? I am reading conflicting views. Whoever raised that question, yeah.
Can you give me a second? Because I did indeed talk about that. Now I'm trying to think off the top of my head if I know. Something tells me it's basic salary, but let me check. Let me check. It's always good to check. Sorry about this. I should know it off the top of my head, but I don't always trust my recollection, you know. Where are we? So I think it is. Maybe I'll go right to the law then. Basic salary. And bear in mind that basic salary is now defined. I mean, it was actually it was defined previously and used for overtime, and I think for some leave allowances too. But yeah, so the basic rule for overtime is time and a quarter, okay, based on basic salary, and then time and a half for leave, if I recall correctly, after 9 p.m. and before 4 p.m. Maybe it's after 10 p.m. and on weekends and holidays and on Fridays. So not Fridays, but weekends. So it's time and a quarter for the basic overtime, time and a half for the higher rate overtime, but it's based upon basic salary. Okay. And basic salary is defined in the labor law as basically as the salary, not the allowances and everything else you get, the employee receives by way of compensation for services.
Okay, we can move on if you.
Let me move on. I mean, we're going to have a lot of questions.
We have lots of questions, but we can always
20 questions already. Okay, that's
okay.
One for every fifth person or more. Anyway.
Slide 6.
Annual leave. I've got a really quick thing on annual leave for you. Okay. You know, in the old labor law, back before we had this new one, there was a kind of a incongruity with part-time employees. You could have them. You could have part-time employees. You could hire somebody and have them come to work 4 hours a day, not 8 hours a day. But the problem was those employees would get the same annual leave as anybody else and the same gratuity as anybody else, right? Because the labor law didn't really have a separate category and a separate way to treat employees who were, you had employees who did piecemeal work or daily rates or things like that, but actual part-time employees, there was not really a special accommodation for them, but now there is. And the one thing I want to say about annual leave, and it applies to gratuity as well, there's now a formula for how much annual leave an employee is entitled to if the employee does not work full-time, okay? Part-time, half-time, quarter-time, whatever it might be. And I'm not going to go into all the details of the calculation. Conceptually, it's this. You take the number of hours the employee actually worked in a year, and you divide that by the number of hours that a full-time employee worked in that year, and you get a fraction. And the employee is entitled to that fraction of the annual leave entitlement, subject to a minimum of 5 working days. So, basically a week for most employees, okay? So that's what you get. There's a little bit of an anomaly here, and the anomaly is if you apply the formula literally, the way it's worded, you find that the employees who work part-time for an employer that has a 5-day work week versus a 6-day work week, you get different leave entitlements. And that's probably not intended, but the formula works that way. So just bear in mind, there's a couple of things in the labor law now. When you get down to a calculation based upon working days and not calendar days, you're going to have these anomalous results. Maybe it'll be fixed going forward by further regulations, but right now it's there. There's a new rule also on leave, which I don't think I talked about before, but sometimes employers want to tell their employees, look, this year, 2021, use your annual leave or cash it in, but don't carry any of it forward. Under the old law, there was a limit on carrying it forward at a maximum of 1 year. Now it's 1/2. The most you can carry forward is 1/2. So if you come to the end of the year and an employee hasn't used all their annual leave, they can carry forward half of the annual entitlement at most, and the rest has got to be cashed in. Can it be forfeited? No. Employees don't forfeit annual leave. It's a statutory entitlement, but it must be cashed in, and there's no other option. Carry it forward, half of it, or use it all. That's the best of all. That's what it's intended for. So the employees don't burn out. But if they don't do either of those, you got to cash it in. Okay. And let me move forward to gratuity and talk about that briefly. Next slide, slide number 7. Yeah. As I said before, the labor law is kind of, and I think I've kind of argued this both ways in the past. It uses a new formula for end of service gratuity. The formula is the same, 21 and 30, but instead of days, it says working days. And that kind of leads to some unusual results once you begin calculating working days, because you get different results for employees who work on 5-day work weeks versus 6-day work weeks. Quite different results. And again, I don't think that's intentional. Not only do I don't think it's intentional, I can tell you the Ministry of Labor people we've gone to talk to, they don't think this is how you should do it. They're treating the labor law as if it's the old labor law, and then the service gratuity is based upon days, not working days. So there's a bit of I think some unintended consequences in there. But the reason I brought this slide up is really not to complain about all that, although I think this is an issue going forward where it's got to be resolved. I think it's just it's an anomaly that I don't think was intended, and it's got to be resolved. But something else in here is interesting. If an employee is working other than on a full-time basis, a part-time employee, then there's also a fractional approach to how much end of service gratuity that employee gets. It's a lot like the approach taken for annual leave. You look at the total days the employee worked versus the annual days the full-time employee, that's full-time workforce worked. You get a fraction, and that's the entitlement to end of service gratuity. It's fractional, and that's a new element. Okay, so employees who are working for 20 years but do it only half-time, they don't get the same entitlement as an employee who worked 20 years and worked full-time for each of those years. Okay, and I'll leave that with you. Look at the formula in the regulations. It's kind of hard to work out, but it is basically actual days worked for the employee in question versus the days worked in a given year for the workforce, for the full-time workforce. That's how it comes out. And that gives you a fraction, and you use that fraction to figure out the employee's actual entitlement to end of service gratuity. Okay. Samara, I see lots of questions. Can I, is it a good time to stop?
Yeah, let's go through some of the questions.
All right, sure, yeah.
I'm just going to try and pick on questions or topics that we've already covered.
All right.
Okay, gratuity calculation.
All right, sure.
What is your understanding of the new gratuity calculation? Does the new calculation apply to the full length of service except year 1, or can we use a prorated calculation with old calculation until February 1st, 2022, and a new calculation from 2nd of February? The reason they're asking is because there was a lot of talk saying that this new gratuity calculation would not have the financial impact for organizations. Is this question clear?
I think it is, and it's a good question, and I'll give you the answer that I think is accurate. I'll give you the conservative answer. Okay. First of all, when an employee's services end, okay? So if an employee's services come to an end on the 1st of March, 2022, how do you calculate that employee's end of service gratuity entitlement? You do it on the basis of the law in effect on the 1st of March, 2022, okay? You take the employee's entire period of service, and you take that into account calculating the gratuity on the basis of the law in effect when the employee's services came to an end. That's the law you use. So it means every employee who's still working today, when that employee's services come to an end, the gratuity calculation will be based upon the new labor law, okay? With regard to the entire period of service, even the period of service that was done under the old labor law, okay? And that's got a number of features that are better for the employees. Definitely they are improvements, they are more generous. One is that, you know, I've mentioned it before, I think, you can't lose your entitlement to end of service gratuity for being, by resignation. That was a provision in the old labor law. Or if the employee is terminated for some reason of misconduct, the 10 specific items listed in Article 120 in the old labor law, Article 44 in the new labor law, the employee does not lose gratuity for one of those reasons. Coming to work drunk, okay, and getting fired, okay? The employer can fire the employee without notice, but the employer cannot withhold gratuity, not anymore. And now the question, and pensions and savings plans, those provisions that used to apply on how gratuity can be replaced by something better, those aren't there anymore, and they haven't come into it. There's nothing has been promulgated to replace those, so that's still an open issue. But what has happened, and it's not a mistake in translation, it's what the labor law says. The gratuity is based upon working days, yom amal. It's there. It's a defined term. The question isn't what does the law say. The question is really what does that word mean. And it looks right. I think the approach to take, the careful approach to take now is that a working day is different from a calendar day because it's a different term. And I think for most employers, a working day, there'll be 22 in a month, right? Based on a 5-day work week. Although if you have a 6-day work week, you'll have 26 working days in a month. So that is, I think, is the new term that is to be used. And does it have a financial impact on employers? Yes, it does. Is this intended? I don't know. But if you take this statute literally, if you apply the way the statute is worded, it has a financial impact. Employees get either 14% more or 28% more than they would have gotten before because of this introduction of the concept of a working day, at least until it's clarified. Okay, I was hoping these regulations, this Cabinet Resolution 1 of 2022, would provide some clarity, but it does not. Okay, so that's still an issue, and I can tell you that the people at the ministry who are administering this statute don't think it's changed. I don't think so. But that, you know, if this goes to a court and a judge reads the statute, he's going to apply the words the way they are written, the way they've been enacted. And yeah, it's different. It's different. And I'm surprised by that. I thought it would have been fixed by the 2nd of February. It wasn't fixed. Okay, so those are my views on gratuity. It's, well, you know, it's different. It's different, a different rule. Okay, they have already, someone says they've already rectified it. What, can you read Kieran's question, Samara? Number 30 or 31, I think it is.
You said Karen?
Kieran, I think. Kieran.
Kieran.
Maybe it's a chat and not a question.
Oh, in the chat, I see. Oh, okay. Oh, you know what?
We're getting stuff in both channels here.
Okay, so you know what? I'm not checking on the chat here. Okay. The Kira, they may have already rectified it. That's what Kieran is saying. That the document is available here, and there's a link to the document.
Okay, I'm going to run that down afterwards. I'm not going to do it right now. You know, Samara, let me just go through the rest of it really quick and then deal with questions, because we're coming up to almost 5:45. Okay. Yeah. Sorry for zipping through all this, folks. Oh, by the way, look, I've looked at the Arabic version, the official version, and about Al Arabiya. You know, I read the Arabic statute and the regs. So I know what I'm talking about. I mean, YOMA is different from just a regular calendar day. So maybe something new has come out though. It could very well be something new since this morning. Anyway, just a couple things. Yeah, specified term contracts. Just bear in mind, folks, we're in specified term land now. Article 10 of the regs makes it clear that we're going to be using the Ministry of Labor form contracts. The old menu option for unspecified term isn't there anymore. So what this means basically is that a specified term contract, when it comes to an end, it comes to an end. And if you don't renew it, it is not renewed. So when end of contract comes along, the very next day, unless something otherwise is done, the employer can terminate the employee's residence permit and labor permit, and the employee can start looking for new work. The contract is over. So as employers, make sure it's diarized that if you want to renew the contract, do it. Do it beforehand. What will happen is that if the parties fail to do anything and the employee keeps on working, then the contract is implicitly renewed by the conduct of the parties for a similar term. Now, that's not so bad, because bear in mind that even though they are specified term contracts, they can still be terminated by notice if there's a notice clause in the contract. And the notice can be anywhere from 1 month up to 3 months. Okay, but bear in mind, we're all in a specified term world now. And if you want to terminate the contract before it ends, there should be a clause allowing that in the contract. Okay, but there's no requirement to give advance notice of non-renewal. It just happens by itself. And it might be good, if you can, to draft something in the contract requiring the parties to at least give notice in advance of their intent to renew or otherwise, like you do with the lease contract. Let me just move on to the next one and just throw a bunch of stuff at you folks. Sorry about this, but we are in a different world now, and unlike before, where there were full-time employees and then there were non-employees, now there are going to be many, many, many different categories of work permits allowed. Conventional ones for full-time employers, where the employees, where the employer sponsors the labor permit and residence visa, but also, visas, labor permits where the employee's visa is sponsored by a family member, temporary work permits, mission visas, golden visa holders, and so on and so forth. Many, many different categories of work permits. They have not all been rolled out yet. If you go to the Ministry of Labor and ask for example, a remote work visa, they'll give you a funny look, but it's there in the regs. And so I expect it will soon be coming out. If anyone has got a remote work visa, by the way, I'd like to see one. I've gotten blank stares in the past, but the idea is an interesting one. And the fact that the labor law now is catching up to the modern workplace is a very good thing. But bear in mind that none of this is, you need a permit for all these things. There's a labor permit for each different kind of employment. The general requirement that an employer must obtain a labor permit or work permit for its employees is there. It doesn't mean it's a free-for-all and you don't need a labor permit. It's all still regulated, but there are many, many more different types of labor permits that are available than was the case before. There's a very long section on employment agencies that detail those. Again, when you recruit employees and provide them on secondment to the end user, as it were, that's all regulated. There are rules for it. They're detailed in the regulations. So it's not a free-for-all, it's regulated, but it's a much more elaborate set of regulations than before. And go to the next slide, Samara, and just what I really won't have time to talk about in detail are like 4 more topics. Go to slide 10. Oh yeah. There's a long section in the regs about, well, actually not very long, but employers are going to be classified and different kinds of consequences will flow from that. So again, bear that in mind. There are fairly detailed rules on the kinds of procedural hoops you've got to go through as an employer to develop workplace rules and disciplinary rules if you want to use those for your workforce. There are criteria for those. There are rules on getting ministry approval. There are detailed rules on workplace safety, employee safety, and what happens if an employee becomes sick or becomes injured while in the course of employment. And last of all, emergency conditions. That's just, we had those. This doesn't mean emergency like the world is ending, but what if things happen that affect the labor market, like COVID? The Ministry of Human Resources and the cabinet generally pivoted very, very quickly to deal with COVID, and suddenly we were able to have our employees work from home because it's safer. They are able to go onto part-time status, to again protect the bottom line of their employers, to retain talent in the UAE without having anyone have to go home. We had a whole series of measures that were taken during COVID to keep the labor force flexible. And what the regs do is they allow the cabinet or the minister to, again, invoke those kinds of emergency powers when exceptional circumstances arise. And it's required by the labor market. Again, what happened before is the UAE was faced with a requirement. Employers couldn't really keep their workforce at full strength during COVID. Revenue just crashed. Remember that? What do? Do you send everybody home? That would be disastrous for the UAE. It would take so long to remobilize. So measures were taken whereby employers could put their employees on temporary leave, on part-time, part-time structures, working from home, things like that, to deal with what was hoped to be and turned out to be a temporary, although severe, disruption. And that power now is part of the regulatory framework. It's there. It could be invoked again. And that kind of, folks, is the end of the last slide says questions, right? Slide number 11. And I think we have quite a few right now. So Samra, pick like 5 or 6 good ones. I'll turn
okay.
Okay. And then I'll have to do this again, maybe, if there are lots of questions. But anyway, let me answer the audience's interests.
Okay, there's a question that came in twice on both the Q&A and the chat. So I'm gonna. It's about work permits. Can somebody, whether a company can apply for a work permit during someone's visa in the UAE?
Oh, yeah. Yeah, you can do that. In fact, a lot of people, will come here on a visit visa and find work. You can then apply for. You got to sort of like treat the employee almost as a new employee. Of course, you apply. You obtain an entry permit, and then you can convert the entry permit into a regular labor permit. There's a conversion application you take, but basically, yeah. And then the person's visa goes from being a visit visa or a tourist visa to a residence visa under the sponsorship of the new employer. That happens. It happens all the time. Sometimes, you bring. You shouldn't really do this, but many employers bring over prospective new employees on visit visas and then convert them once they're here, just because it's easier to enter the country. Bear in mind, you're really supposed to get the entry permit because a visit visa isn't really an employment visa. But yeah, if a person's here on a visit visa and they find a job, can the employer sponsor an entry, a labor permit for them? Yes, of course. It happens a lot. It's a slightly different procedure, but it's one that's done fairly frequently. So yeah.
Okay. Another question that was repeated, if the employer may, and the key word here is may, the employer may agree to grant the worker a leave from his annual leave balance during the probationary period, while the worker shall reserve his right to be compensated for the remainder of his annual leave balance in case he does not pass the probationary period. Is this a mandatory requirement or optional?
That's the normal rule is you don't get any leave entitlement during your probation period, but but the contract can provide otherwise. And that's what this is addressing. It's kind of redundant in a way because the contract can do that, but it's saying expressly if you do provide in the contract that annual leave entitlement will accrue or begin to accrue during the probation period, then it will have that effect.
Mm.
So yeah, it's
Yeah,
fine.
it's okay.
It's fine. So what it means literally then is that you'll get, I think it's what, two days per month. I mean, it'll happen during those initial up to 6 months of the probation period. Some people ask me when do you get, you know, let's take an employee who passes the probation period and then passes the first 12 months of employment. That employee gets a full year's worth of annual leave. The first 6 months do count. You know, once the employee completes the probation period and then completes the first year of employment, that employee becomes entitled to 30 days at least of annual leave. Just bear that in mind. Not 15 days, but 30 days. You begin the count from the first day of the probation period, not from the end of the probation period.
Okay, another question, since we're talking about probationary periods, if we need to notify an employee that he has not passed the probation period, do we need to inform him 15 days before his probation period ends, or can we notify him the day his probation period ends, and then we need to give him 15 days notice?
Yeah, that's a good question, because there's a provision in here that it says, you know, 14 days advance notice in writing, and yeah, I guess if you decide on the very last day of the probation period that the employee isn't one you want to keep, I guess you give them notice, and I think it's going to go like this. I think you give them notice. The notice becomes effective after 14 days because that's what the law says, but then it's still effective. So you have to pay the employee for 14 or 13 extra days of employment, but then they go. So I don't think it's a question of you can just forego the notice period, but you give it. It's still a requirement.
Okay, another quick question on annual leave salary. Is it A, HRA plus basic, or B, full salary?
Annual leave. You know what's kind of funny about that is that it's different depending on what you do, and this is another one of these little anomalies I was hoping would be resolved and wasn't. Let's say you have an employee who worked through the year, didn't take leave, and wants to cash in this unused leave, okay? The employee will do that on the basis of salary, the full salary, okay? But if they come to the end of their employment and they want to then cash in unused annual leave, that will be cashed in on the basis of basic salary. So it's not the same rule. And I thought it would be. I thought it would be the same rule, but it isn't. And that is clear from the regulations. It wasn't clear before.
Okay, interesting.
And yeah, it's interesting and again somewhat anomalous, but you know, it is what it is.
Okay.
I guess we have time for one or two more.
Yeah. Let me try to. Okay? I'm going through some of the quick questions. Is a contract employee or contract employees for 6 months or 12 months are they eligible for annual leave if they're just on a 6-month contract or a 12-month contract?
I think 6 months, the answer is not unless you say so in the contract. 12 months, yes, they would be.
I see. Another question, do employers have to expressly replace all existing unlimited employment contracts with limited term contracts?
Yes, they do. That is a clear requirement. That was in the statute, not just in the regs. And you've got a 1 year period, a grace period, if you want to call it that, within which to replace your existing contracts. So this is actually fairly burdensome. The fact you've got a year to do it helps, but don't wait until January 2023 to do it. If you, like most employers, perhaps most of your employees are serving on unspecified term contracts, and now some of those are going to come up for renewal perhaps during the next couple of months, next 12 months, and when you renew them, you'll have to replace them with a specified term contract because the Ministry of Labor forms require that now. But if you have someone who will be due for renewal perhaps after February 2nd, 2023, do you wait until the renewal date? No. Before that day arrives, before 1 year has passed under the new law, replace all of your unspecified term contracts with specified term contracts. Do that. It is a requirement. Will it be extended further? Maybe, but right now it's a requirement to do it within 1 year. And I know we're doing it in Afridi Angell. So but I know some of you out there have hundreds of employees, and I'm sorry to be the bearer of bad tidings, but you're going to have to go and replace all those contracts.
Mm. Do you want to take any more questions, Charles, or should we wrap it up and then address those questions offline?
Yeah, I think we can wrap it up. Because everyone, I don't want to cut you all off, but last time this happened. I got more questions than there was time to answer. But you all of the questions are in the chat or in the Q&A function of this Zoom meeting, and I actually did send answers around, and I'm going to do that again. So all of you, I guess, since you registered, since you signed up, we know who you are, and we know your email addresses. And what I'll do is I'll try and put together answers to all these questions. Sometimes you might find that there's 5 questions. It's the same question, so I won't be answering 60 questions. It'll be more like probably 15 or 20. But that's okay. I don't mind doing that. And it's as long as you all understand that maybe I'm wrong. I'm just giving you what I think the law and the regulations mean. But it's kind of a moving target right now. And I'll give you my best opinion as to what the state of the law is in response to your questions. Okay.
Great, thank you.
Thank
you, Charles. Yeah, makes sense. Yeah. Makes sense. And thank you, everyone. I've answered some of you privately. We will be sharing the webinar recording with everyone, and the slides and the questions, which Charles will put in categories to make sure to avoid some overlaps. And and if you have any other questions, you have Charles's contact details. You can feel free to contact him directly. And
email me, please. I'll get back to you. Yeah. Don't phone me, or my phone will be ringing nonstop for weeks. So.
Yeah. And thank you very much, everyone, for joining us. Have a great evening.
Appreciate it. Thanks for the questions, everyone. Really appreciate it.